Good afternoon or good morning, depending upon where you're at. I am Tony Vernetti, the president and founder of FEDS, Federal Employee Defense Services. I want to thank everybody for attending today's webinar on liability insurance for federal veterinarians. Before we get started, just a little information about myself. I'm a former federal employee. I was an attorney in the federal government for several years, and then I worked many years in private practice defending federal employees at a variety of different agencies. These webinars typically take about an hour and a half, but we realize that you all really don't have that kind of time, so we created this abbreviated version to give you the essential information in a short amount of time. So I have a lot of material to get through in 15 minutes or so. So I'm going to ask everyone to please hold their questions until the end, and then I promise I'll stay on as long as necessary to get everybody's questions answered. So liability exposure for federal employees in general really began back in June of 1971 with the Supreme Court decision called Bivens. And this case allowed federal employees to be sued personally in their personal capacity for the very first time. And it was in response to this ruling that the concept of federal employee liability insurance was created. And then also Congress passed legislation requiring federal agencies to reimburse certain federal officials up to 1/2 the cost of the annual premium for this liability insurance. And the grouping is managers, supervisors, and law enforcement officers. As federal veterinarians usually fall into the manager or supervisory category for the reimbursement. I start the presentation with this slide because I think it's really important for you to appreciate that this official support for liability insurance by Congress really demonstrates their understanding that there are risks associated with your federal employment that they cannot cure with legislation. They want you to have this protection, and they want to share the burden of the cost with you. I should also mention, I usually get a question here in live in other presentations, all federal employees are eligible for the liability insurance, not just managers, supervisors, and law enforcement officers. All federal employees are eligible and should consider getting it. It's just that grouping are the ones that have been identified by Congress to get the reimbursement. They feel they have the most vulnerability. It doesn't mean other groups don't have vulnerability as well. So when we talk about liability insurance, I like to break it down into 3 categories. Your civil exposure, your administrative or job exposure, and criminal exposure. I'm going to start with civil because this is what most veterinarians associate professional liability with. And in fact, there's a big case back in, I think it's early 2000 or late 1990s out in San Francisco involving some food service inspection service inspectors who were actually held personally liable in a lawsuit. And that created a lot of stir and buzz amongst the USDA employees because I believe those inspectors did not have the liability insurance and kind of were out there on their own. So shortly, the insurance really got started for the civil exposure, for the fact that you could be sued in your personal capacity, and then shortly thereafter, policies added the administrative and criminal protections. But again, I want to start with the civil exposure. Civil suits are typically referred to as Bivens actions, constitutional torts, personal capacity, and individual capacity lawsuits. As veterinarians, and some of you are veterinarians in private practice, this area is what you really associate why you need liability insurance and malpractice insurance. But as you will see a little bit later in the presentation, it really is not the primary reason why you need liability insurance. So civil. The main thing that you need to appreciate for these, what we call personal capacity lawsuits, is that you don't have absolute immunity for these personal capacity lawsuits like you do for the Federal Tort Claims Act. Okay, the federal lawsuits under the Federal Tort Claims Act, which is what we call common law torts, give you absolute immunity. It's essentially a case against the federal government. And whether you're named individually in an FTCA lawsuit, the government will always substitute its name for that. We're talking about these separate kind of lawsuits here today, the personal capacity, individual capacity lawsuits. And there's just three concepts I want you to take away today, and it's representation, immunity, and indemnification. Okay, first let's deal with representation. If you get sued, the first thing you want to know is who's going to defend me. And a lot of people are surprised to learn that DOJ representation is not mandatory and it is not automatic. Okay, it is the sole discretion of DOJ to determine if it is in the interest of the United States to provide you representation. You need to be within the scope of your employment, and DOJ, Department of Justice, needs to conclude that it is in the interest of the United States to defend you. So if you're being investigated for the very same reason that you're being sued, if you're being investigated for some sort of wrongdoing by your agency or some other entity, and you are sued for that very same manner, you can see the Department of Justice, the federal government, is not going to want to be on both sides of that, and they're going to decline representation, and you're going to have to retain your own counsel, unless, of course, you have the liability insurance. The next concept I want to briefly talk about is immunity, and I've already alluded to this. You have absolute immunity under the Tort Claims Act. You do not have absolute immunity for these personal capacity lawsuits. You only have what's called qualified immunity, which is pretty darn good. And this is not a law school class. I'm not going to get into all the specifics of it. Just trust me that it's still pretty good protection, but there is a chance you could be held personally liable, and that has to do with this final concept of indemnification, because even if DOJ is representing you, what you need to appreciate is that it is still a lawsuit against you personally, and if DOJ represents you and loses, and your agency declines to indemnify you, you could still be held liable for the judgment. Okay? So liability insurance protects you in these three ways, essentially. It provides, if DOJ declines to represent you, the liability insurance will provide that representation for you. And if, in the unfortunate event that you are found personally liable, that's what the indemnity protection is there. You have this judgment protection in $1 million or $2 million, depending upon the type of policy you purchased. So a quick recap of civil is, I want you to understand you can be sued, DOJ can deny you rep, and you can actually be held personally liable involving something with your federal job. The liability insurance protects you in these three ways: legal defense, pays damages, and this coverage counsel. I didn't mention that earlier, but essentially what that means is if DOJ is on the fence as to whether they should represent you, we may hire coverage counsel to convince DOJ that it is in the interest of the United States to represent you, or in particular egregious cases, we may, even though you're being scoped and repped by DOJ, we may still want to hire coverage counsel to sort of oversee and just stay informed on DOJ's legal defense of you to assess whether there's going to be any civil damages. A final point I want to make before I leave civil is that civil suits without Department of Justice representation are rare, okay? I want you to appreciate that. They're rare, with actual liability being even rare. Probably about 5% or even less than 5% of the cases result in DOJ denying rep and there actually being liability. In fact, if you ever attended an agency seminar and they were counseling you against getting liability insurance, this is the perspective they're looking at it from. They feel the chances are very low, so you're probably okay not getting the insurance. But no matter what the percentages are, for $135, which is all the policy costs after the reimbursement, why would you risk it? Why would you be one of the ones that slipped through the cracks? And I again, reference that case that happened a decade ago out in San Francisco. So this is the real bang for your buck as federal veterinarians and other officials that deal with inspecting our food products. Administrative matters. So this is any administrative investigation that can result in a personnel action against you. We're going to cover you. We're going to provide you legal defense up to $200,000 from the start of any investigation throughout the conclusion. In the unfortunate event that there's a disciplinary action against you, we're gonna defend there as well, both at the MSPB level, or if we got to appeal it further, the $200,000 covers that as well. The policy also, and before I get there, these are some of the allegations that we've seen in the past 4 or 5 years in defending FSI, federal veterinarians at various different agencies. The failure to ensure that meat and poultry products are safe, accurately labeled, oversights and errors in making food product recalls, failures to efficiently and effectively handle recalls, oversights causing increased vulnerabilities, failures to ensure protection of animal and public health. We've seen a lot of cases involving that. The OIG, OSC type investigations typically deal with managerial issues. Congressional oversight, we'll talk about that in a little bit, but essentially your takeaway here is any administrative matter that can result in a personnel disciplinary action against you is going to be covered by the liability insurance, and you get your own lawyer to defend. And you also get your own lawyer to defend if there's a state veterinarian medical board investigation or proceeding arising out of the performance of your duties. It covers that as well. Just a real quick word here about Inspector General investigations, IG investigations. Every major agency has an Inspector General office, and they're designed to, they're the agency's watchdog. They're supposed to look out for fraud, waste, and abuse, and gross mismanagement. Often I hear people who are the subject of an IG investigation tell me, I didn't do anything wrong, and if I did, I surely can't explain. Or, if I show up with a lawyer, they'll think I'm guilty. Okay? Applying those concepts on your own without getting legal advice, trust me, you will not fare well. It is important to be properly prepared for any IG interview. It's important that you understand your rights. Not every request for an interview by the IG is mandatory. Often they are voluntary. And submitting to a voluntary interview is also a waiver of your Fifth Amendment right to silence, which is something you should never do. You should never waive a constitutional right before speaking with an attorney. Office of Special Counsel investigations typically are going to involve managers, whistleblower reprisal, prohibited personnel practices, violating the merit principles, something involving irregularity in the hiring practices. I want to mention this here because often an OSC investigation feels like, while you're being named as one of the subjects, it also feels like it's an investigation against the agency, and the agency may have lawyers involved also defending the case. But it's important that you appreciate that the lawyers for the agency are the agency lawyers, not yours. Their duty of loyalty is to the agency. They could be advancing an interest that's adverse to yours. It's important that you get your own legal advice if you are the subject of an OSC investigation. And again, the liability insurance covers OSC investigations. Congressional oversight investigations are hearings. Sometimes and often it's a career employee that becomes the target of these types of investigations. And as all you know, there's a lot going on in the world of food safety. Just this Monday in the Washington Post, there was an article citing to many food and safety experts. They were being very critical of the USDA and the FDA, and they were emphasizing that there was a need to overhaul the way agencies inspect our food products to ensure that they're safe for consumption. So, you know, what you do every day affects the public, and it can get and does get some media sensation. And if you become a subject of one of those inquiries as a result of that, it's important to have your own legal counsel advising you along the way. EEO complaints. I'm often asked, why do I need liability insurance for an EEO complaint? Isn't it a case against the agency and not me personally? Well, that's true. It is a case against the agency, so you can't be held personally liable. But if there is a negative conclusion, a discriminatory finding, you could be disciplined. You could have accountability in a disciplinary administrative matter. So we want to get in the initial stages and assist you during the investigation phase and assist you for that EEO investigation. Because again, while the agency has lawyers that will defend, their duty of loyalty is to the agency, okay? They are not your lawyer. Often your interests are aligned, don't get me wrong, but it could be important for you to get your own separate legal advice. If for nothing else, just to have a lawyer explain your role in the process. Often federal managers, federal officials are not aware of what their role is in the EEO process. All you know is you get a phone call, knock on the door from an EEO investigator, you know, that says, I need to ask you some questions. Well, you as the manager are responsible for making a record of what's called the legitimate, non-discriminatory reason for doing whatever you did or did not do. That's the piece of evidence that your agency lawyers are going to use to defend against the EEO case. And if you were a Feds member, you could elect to receive coverage and get advice from an attorney if an EEO complaint is filed against you. And I've talked about this throughout the investigations, throughout talking about the various investigations. This is essentially what the insurance will provide when we appoint an attorney in an administrative matter. Defends, prepares you for the investigation, could attend the interview with you, and ultimately would defend any disciplinary action. Here are some real-world examples that we've experienced over the past 4 or 5 years involving federal, these are actual cases here, involving federal veterinarians. I'll just take a minute here and let you read through these and digest them. They're intentionally sort of vague because for attorney-client privilege reasons, we have to omit certain facts and certain things so that, you know, we couldn't, you know, determine who the actual individual is. But this is a real good sampling of administrative matters that we've seen over the past 4 or 5 years. Finally, the final exposure area, and very quickly, criminal exposure. Now, I know as federal medical officials, veterinarians, you do not come to work every day to violate criminal law. But what's important to understand is that there's very little you can do wrong in the federal government and not also have it technically be a violation of Title 18, which is the criminal code. Common allegations include conflict of interest statutes where intent is not a prerequisite, misappropriation of federal funds, release of Privacy Act or other statutorily protected information, maybe industry proprietary information. You know, any situation arising out of a misuse of a position or authority could result in a criminal investigation. And you remember when I talked about the IGs early on, Inspector General offices, you have to understand that they're law enforcement investigators. They're criminal investigators first. They're special agent criminal investigators. So often every investigation, no matter how benign or administrative it may seem, may start off as a criminal investigation. And it's absolutely important for you to talk to or retain criminal defense attorney before you talk to anyone if you are notified that you are the subject or there is an ongoing criminal investigation. And the Fed's policy provides a lawyer for that. This is just a recap of what the liability insurance provides. You know, I've been defending federal employees for, over 18 years now. And whether the complaint comes from a member of the public, special interest group, industries, politically motivated officials, a subordinate employee, other employees, your agency, the thought that an investigation requiring you to get legal counsel could never happen to you is very naive. It's very naive. It's just the cost of doing business nowadays. You're just not going to get through a career in the federal government, particularly in management, and be doing your job appropriately and not have somebody file a complaint against you. And when you do, it's comforting to know that you'll have an attorney experienced in federal law to defend you. Even if you're ultimately vindicated of the allegations, which often many of you are, at $300, $400 an hour, which is what attorneys charge these days, the cost will add up very, very quickly. You'll spend more in 1 hour of legal services than what the policy actually costs. And this is what it costs. $270 for the $1 million, $370 annually. And as you recall, if you're a manager or supervisor, the agency will reimburse you up to 1/2. I should also mention here that Feds is specifically endorsed by the National Associations of Federal Veterinarians, and their members, they get an association discount with Feds, a $10 discount. And if you are a member, contact NAFE main office to get the discount code, or you can just contact us here at Feds. I should also mention here that payroll deduction is available at $12 a pay period for the base policy. This is my final slide, and I can't emphasize this point enough. The policy needs to be in place before something happens. Just like your home or auto insurance. You can't get in a car accident on Monday, buy your insurance on Wednesday, and expect to be covered. I can't tell you how many times I get calls or we have people signing up for the insurance after their house is on fire. Okay? There are 3 ways to get enrolled. You can go online. It takes less than 5 minutes. We can send you a 1-page enrollment form, or you can give us a call. We'd be happy to get you enrolled over the phone. So that concludes my presentation today, and I would like to now open it up for questions.
Okay, Tony, one of the questions is, what determines who is a supervisor or manager? For example, my official job description or the job you are performing?
It's a combination of both. I get this question a lot, and ultimately the agency is going to have discretion to determine it. But it's meant to be liberally interpreted, and it means the manager, definition of manager and supervisor means something beyond, whether you're actually supervising individuals. You could be involved in policy management level stuff that meets the definition, and you're still eligible for the reimbursement. The definition is in the Federal Labor Relations Management Statute, and that's another way of saying if you're ineligible to be part of a collective bargaining agreement, the union, because of your managerial or supervisory status and duties, then you should be eligible for the reimbursement. Now, the individual who maybe is in a position that clearly is not eligible for the reimbursement, but the agency actually has them doing, some other work, some other managerial supervisory duties, the majority of the time, if it looks like a duck, quacks like a duck, it's a duck. I would think, regardless of what PD you're under, you should still be eligible for the reimbursement. If you're someone in that category, I would encourage you just to call our office, and we can work with you to see if you're going to get reimbursed with your agency.
Okay, another question is, when is your enrollment period?
It's the beauty of feds is there's no enrollment period. You can enroll anytime. There's no open season. You know, in the federal government, as you know, there's one open season each year in late fall. With this type of insurance, you can get enrolled anytime. You can sign up today, pay online with a credit card, and it's effective today, effective immediately.
Okay, Tony, it looks like that's all of our questions.
Okay, I'd like to thank everybody for attending the webinar, and hopefully you've learned some information and will consider getting yourself protected with liability insurance.